Dr. Benji, a medical practitioner who qualified in 2003 and worked at the Royal Free London NHS Foundation Trust as a specialty trainee in emergency medicine, faced a hearing at MPTS for his misconduct towards patient A. The allegations include engaging in an improper emotional relationship with patient A, and behaving inappropriately and/or unprofessionally towards patient A on various occasions through WhatsApp messaging. Dr. Benji has admitted to all the allegations, and the tribunal has found them proven. Dr. Benji met patient A on June 5, 2020. After a clinically indicated examination, patient A was discharged, but she herself gave Dr. Benji her telephone number. Dr. Benji initiated contact with patient A via WhatsApp, which then developed into an inappropriate relationship involving activity in the hospital toilets on June 10, 2020. They continued to exchange messages and medical advice until July 24, 2020, when their relationship petered out. Dr. Benji was arrested on suspicion of assaulting patient A on June 10, 2020 but was not charged with the offense. He disclosed his arrest to the GMC on August 5, 2020. The Medical Practitioners Tribunal took into account all the evidence received so far, including a witness statement from Dr. Benji, a witness statement from his responsible officer, 2 character statements in support of Dr. Benji, and various documentary evidence such as a self-referral by Dr. Benji, hospital records of patient A, and WhatsApp messages. The tribunal will make a determination based on the facts that have been found to be proven. The tribunal's determination on misconduct and impairment included the following reasoning. In her submissions, the Counsel, on behalf of the General Medical Council, reminded the tribunal that it must determine whether the facts admitted and found proved amount to misconduct before considering the question of impairment. She referred to the cases of Roylance v. General Medical Council and Meadow v. General Medical Council, where it was observed that misconduct involves acts or omissions which fall short of what was proper in the circumstances. The Counsel submitted that misconduct must be serious and linked to the practice of medicine. She argued that the conduct outside the practice of medicine might qualify if it was of a sufficiently immoral or outrageous and disgraceful character because the reputation of, and public confidence in, the profession could be adversely affected. The Counsel reminded the tribunal that Dr. Banji and Patient A engaged in a relationship for approximately 6 weeks before it faded out, although there were only 2 occasions when they had been intimate. She submitted that the sending of improper and unprofessional communications to a patient, particularly so quickly after leaving A&E where she was treated by Dr. Benji, would, on its own, amount to misconduct. Further, being intimate with a patient while on duty, within the toilets of A&E department, where the patient had attended for treatment, also amounts to misconduct by itself. The Counsel argued that continuing the relationship for approximately 6 weeks and sending inappropriate and graphic communications to a patient amounted to misconduct by itself. Providing medical advice to an intimate partner via WhatsApp and without maintaining proper clinical records also amounts to misconduct by itself. The Counsel submitted that the tribunal should consider whether Dr. Benji has brought the medical profession into disrepute or is liable to do so in the future. She highlighted the fact that Dr. Benji recognized the seriousness of his wrongdoing in his witness statement. Dr. Benji's legal representative submitted to the Medical Practitioners Tribunal that his client fully understood the gravity of his conduct and accepts that his behavior over the relevant period amounts to misconduct. The Counsel acknowledged that a finding of impairment is likely to follow. However, he informed the tribunal that Dr. Benji has made considerable progress in addressing his behavior since 2020 and has the support of his wife, colleagues, and a pastor who provided counseling. The Counsel also asserted that Dr. Benji has significant insight into his behavior and that it will not be repeated. The Counsel further conceded that in inappropriate relationship misconduct cases, the public interest is of particular importance, and it is crucial not to leave the public with the impression that no action has been taken against Dr. Benji by the tribunal. The tribunal found that Dr. Benji's actions towards patient A, as outlined in the allegation, constituted serious misconduct. The tribunal found that Dr. Benji's actions, including inappropriate communications, breaches of guidance and regulations, and 2 instances of intimate activity with patient A, were deplorable and brought the medical profession into disrepute. The tribunal found that Dr. Benji's behavior fell seriously below the standards expected of a doctor and represented serious breaches of the principles of good medical practice. The tribunal has found that Dr. Benji's actions amounted to serious misconduct, and has considered whether his fitness to practice is currently impaired. In making this determination, the tribunal looked for evidence of remediation and insight, and considered the likelihood of repetition, balanced against the 3 elements of the overarching statutory objective. The tribunal considered the 3 limbs from the relevant precedent and noted that Dr. Benji himself conceded that his fitness to practice was impaired. The tribunal found limited evidence of insight or remediation and determined that the public's trust in the profession would be undermined if a finding of impairment was not made. Therefore, the tribunal has concluded that Dr. Benji's fitness to practice is impaired by reason of misconduct. The tribunal concluded the sanction stage with the following reasons. The MPT considered the aggravating factors, which include Dr. Benji being intimate with patient A on hospital premises while on duty, abusing his position of trust, and engaging in an inappropriate relationship over 6 weeks, and the mitigating factors, which include Dr. Benji's full and early admission of the allegations, his good level of insight, and repeated remorse for his actions. After considering these factors, the tribunal concluded that taking no action would not be appropriate, and that conditions would not be sufficiently serious to mark the severity of Dr. Benji's misconduct. The tribunal then considered a suspension, which was deemed necessary to protect the public and maintain confidence in the profession, as Dr. Benji's misconduct was not considered to be fundamentally incompatible with his continued registration. The tribunal was satisfied that Dr. Benji had insight and did not pose a significant risk of repeating the behavior. It was also noted that the relationship was initiated by patient A herself and Dr. Benji did not approach her with the said intent. The tribunal decided to direct a review of Dr. Benji's case. A review hearing will convene shortly before the end of the period of suspension, unless an early review is sought. The tribunal clarified that at the review hearing, it will be Dr. Benji's responsibility to demonstrate how he has addressed this tribunal's concerns. It therefore may assist the reviewing tribunal if Dr. Benji provides evidence of continuing remediation, and a further reflective statement. The tribunal concluded that in cases of serious misconduct of the kind found proved against Dr. Benji, the public confidence in the medical profession would be undermined further if a sanction of suspension was not permitted to take effect immediately and would cause further harm to the reputation of the profession. The tribunal determined that the only way to mark the seriousness of the doctor's misconduct is to impose an immediate order.